Lecture number 3, third party rights in a contract. We have learned that a contract is an agreement creating and defining rights and obligations of the parties. So in this context, I wish to ask you two questions. Question number 5, who is having the rights under the contract and hence entitled to enforce the same? Question number 6, whether any third party, that is someone who is not a party in a contract, could have a right under this contract. Let us try to understand about third party rights through an example. Assume there is a contract between developer and contractor for the construction of residential tower. So here we are having real estate developer and here we are having construction contractor. Both of them have signed a contract where construction contractor is responsible for the construction of residential tower for the real estate developer. And assume there is another contract between developer and home buyer for the sale of apartments. So here we are having real estate developer and here we are having home buyer. Both of them had signed a contract for the sale of apartment. In this situation, if a home buyer finds construction defects in the apartment or building after taking possession, which are due to the reasons of the construction contractor, what recourse is available to the home buyer? Please note that here under the construction contract, home buyer is a third party as there is no direct contract between home buyer and construction contractor. So the question arises, can home buyer sue the construction contractor for construction defects? Though there are ways to incorporate third party rights in a contract, however, let us first see a general rule called the rule of privity of contract in this regard. The rule of privity of contract is a principle that a third party cannot sue for damages in a contract to which he is not a party. As per the common law doctrine of privity, a contract cannot generally confer rights or impose obligations arising under it on any person except the party to it. So considering rule of privity of contract, we can say that home buyers cannot sue the construction contractor for defects in the apartment or building. Now let us look at another example on the subject. So here we are having a project owner and here we are having a construction contractor. So both of them have signed a contract where construction contractor is responsible for the construction of residential tower for the project owner. Now in order to construct the residential tower under this main contract, construction contractor has engaged a subcontractor for the execution of structural work. So both of them, mean construction contractor and subcontractor, they have signed a subcontract agreement. Now the question is, can project owner sue the subcontractor if it finds defects in the structural work after project completion? The answer could be no. Due to the rule of privity of contract, the answer is no. So now another question is it possible to include project owner as the beneficiary of defect liability clause under the subcontract agreement? So the answer is yes, it is possible. Third party rights could be introduced in the contract and this gap could be bridged. And the two options for doing this are explained in the next slide. Third party rights may be included in the contract via third party rights clause and collateral warranty agreement. Third party right clause. Project owner's rights could be included in the subcontract agreement by incorporating a clause titled third party rights or third party beneficiary in the subcontract agreement. Contracts Rights of the Third Party Act 1999 is a specific law in England and Wales in this regard, and parties could include third parties' rights in their contract as per this law. However, third party to be specifically mentioned in the contract and what rights the third party is having should be clearly stipulated in the clause. This is not a common practice in engineering and construction industry, and you may not see such clause, that is a third party right clause, in most of the contracts. Now let us talk about the second option is collateral warranty. So by signing collateral warranty agreement between the project owner and the subcontractor, the third party rights of the project owner could be introduced. Collateral warranty is a side agreement connected to the main agreement. This is a common practice in construction and engineering industry to include third parties' rights, particularly for such defects and breaches which impacts the third party.